All right, so today we have Gabriela Zanfir-Fortuna, VP for Global Privacy at the Future of Privacy Forum, and Andrew Burt, who's been on the podcast many times, the managing partner at BNH.ai, the first law firm focused on AI and analytics. And today we will discuss the year 2023 and what it brings in terms of AI regulations. And we will focus mainly on the EU AI Act. So Gabriela and Andrew, welcome to the Data Exchange podcast.
Hello, Ben. Thank you for having us.
Great to be back.
All right. So I will start with kind of the basics before we get into the actual details. So first basic question is EU AI Act, best guess, and both of you can answer. You might have different guesses. When will it actually be in place?
Let me start with that and be overly optimistic and say that we might have a final text in, let's say, October next year. So the fall of next year. And
which by the way, we're recording this December 2022. So she means October 2023.
Indeed, I mean October 2023, and this is because we just had a big milestone that happened 2 weeks ago, so early December 2022, with the EU Council adopting their general approach, their version of the AI Act. So now we have the EU Commission original proposal, the version of the EU Council, and this means that the government of the EU member states, the governments of the EU member states agreed on their position of negotiation for the text. And now we're waiting for the European Parliament. There are signs we'll see their position adopted in March. And if this happens, the three institutions will negotiate among themselves for the final text, and we might see it early fall. But that is the optimistic scenario.
Andrew, early fall, what does that mean? So let's say Gabriela's right, it passes in October. What does that mean in terms of enforcement?
So I have to say, I can be a little bit skeptical when it comes to what it actually means for a lot of the regulations that come out of Europe in terms of first of all, the substance of the regulation, and then once they're passed, and then once they begin to be enforced. Gabriela would know better than me the actual enforcement date. I don't know if there will be, if there's expected to be a grace period in between when it's actually expected to be kind of passed and signed off, and then when it'll be enforced. But I think from my perspective and kind of the advice that I'm giving to clients and watching clients get ready for this, and Ben, this goes into thinking about 2023 writ large, is this is just one piece of a much larger pie where organizations need to be ready to demonstrate that they have gone through kind of appropriate risk reduction procedures for their AI. So I don't know the exact date. I would love to hear what Gabriela thinks in terms of when will this thing actually start to be enforced? But I think big picture, I would advise clients already, and I think we'll talk about this shortly, to start preparing for it, because generally, I think it's clear what it's going to look like at a high level. I think generally the other types of requirements that are coming down the pike in the US are clear. And so I don't think there's any reason to actually wait. And the longer organizations wait, the harder it's going to end up being to comply.
So let's set aside the actual date, but so another question before we get into what it is let's say I do nothing at all. So what's the anticipated penalty if I get in the crosshairs in the worst case scenario?
I mean, I guess the main problem would not necessarily be on the fining side, but on not being able to put your AI system on the market in the European Union, which continues to be one of the big markets in the world, right? So I would say that's where I see the highest risk there for those that are developing right now AI products that embed some AI system.
Well, what does that mean in terms of there's thousands of companies, so I'm one company. Will they know that I did nothing?
Well, this depends on exactly what Andrew mentioned earlier. You know, how will we see this thing implemented in reality, and how will it manifest in terms of enforcement? Now, the I don't know to call it a good or a bad news, but the news is that there is a lot of ambiguity at this point with regards to who is going to enforce all of this and who is going to be that agency or that authority that will be mainly responsible for monitoring compliance with the AI Act and for looking at products that are on the market in the EU and raising red flags. So there's actually a lot of debate in Europe right now with regards to who this authority should be. What's very relevant to mention is that it looks like we will have to deal with authorities in each of the member states, just like with the GDPR, as we're doing now, who will coordinate to a certain extent at EU level through a board that will function in Brussels. But this architecture is still on the move. We don't have the final answer here. I would only add to this that there are several authorities of member states, you know, and government agencies in Europe that are interested in having a stake in this. Data protection authorities are some of them. But there are also other authorities that are interested in becoming the enforcers of the AI Act. And governments are also looking into creating new authorities that are dedicated to the enforcement of the AI Act. So the whole landscape is pretty much on the move, and it will depend then on the maturity of the authorities that will be finally designated to enforce it. On whether they will immediately react and sort of raise red flags and just not let companies put their products, including AI systems, on the market, or not. You know, maybe we'll see new authorities that will just need 5 years to mature. But yeah, it's a big mess, I would say, from this point of view.
So, Andrew, few red flags there. First is you know, different countries have different resources, capabilities, resources. And then secondly, I go back to my question around, okay, I get that if I'm one of the big tech, high profile tech companies, that's one thing. But if I'm a startup with, say, 10 to $90 million in revenue, you know, slightly still below the radar. I mean, there are a lot of startups in that category that we've never heard of, right? So,
yeah, I mean, there's this. So I realize that you have yet to ask a question. I'm just talking. So yeah, feel free to ask a question. And but I think there's this real, and we come across this all the time. There's actually in U.S. legal doctrine, there's a theory called efficient breach theory, which actually encourages people to break the law. This is somewhat debatable. If it is basically less expensive for them to break the law and then get fined than it is for them to comply. So there are all of these really interesting, big and complex kind of business decisions and risk decisions that are being made. And I think that's what you're touching on, which is if you're below the radar, practically, you know, from a business standpoint, what actually makes sense. And I would say that's a really interesting and hard question, but I think I have the luxury of just ignoring it entirely because what happens in the EU doesn't really matter. Again, back to like, this is one smaller piece of a bigger pie. it's not just the EU.
Right.
We're seeing the same type of trends happen all across the
And,
board.
and yeah, and we'll go over these different rules in a second here. But now, okay, so now let's go to what is this EU AI Act? And I have to say, it's a bit vague. It seems like it's more descriptive than anything else. So it seems to kind of identify, I don't know if this is the right word, sectors or verticals in its language. So I guess it's categorical in nature, right? So the unacceptable risk, high risk application. So Gabriela, so how would you describe what is covered?
I would describe it as being a very ambitious piece of legislation because it intends to cover not really specific verticals related to AI systems, but AI systems overall.
But wait. So
And
before you continue,
yeah,
the reason I say verticals is because it seems like the lobbying in Europe seems to be, certain industries are lobbying to make sure they're in certain, they're categorized in a certain way. Like the insurance industry wants to be.
yeah.
So
So
am I misinterpreting?
No, I don't think you're misinterpreting it. And before going into that, let me just briefly mention that this is a very technical piece of legislation. It's very difficult to approach. The language that it uses it's difficult to approach. It's a highly bureaucratic type of text, I would say, and it has a web of provisions that are difficult to map. It's very, let me put it this way, it's exemplary for how some of the EU legislation has been built over the years in terms of being very technical. And it borrows a lot from the product safety type of legislation that we've seen in the EU across the years. So very difficult to approach, very technical. In terms of the verticals you're mentioning, I think you are seeing this because the core of the AI Act focuses on high-risk AI systems and the obligations attached to high-risk AI systems. So then it's very important, it's almost vital for some of the industries on whether they will be covered as being a high-risk AI system provider.
But the high risk is spelled out, right? Like
high risk is spelled,
credit
yes.
scoring, employment, this kind of thing.
Yes, there is a finite list in one of the annexes to the draft regulation that spells out the high-risk AI systems. But during the negotiation process, before we see the final text, we can see that list shifting. Plus, there's also the rule that the AI regulation proposes for the European Commission to be able to revisit that annex by itself. So not going through the whole legislative process, but being able to review it periodically to make sure that it's updated. So what we've seen now, for example, with the the Council, and I told you that we just saw its final version of its mandate to negotiate this act, the Council actually added to the original list of high-risk AI systems. And it's funny that you mentioned the insurance industry because some of the things that they added have to do with, for example, insurance, life insurance and health insurance, if I remember correctly. And they added that sector to the list of high-risk AI systems. And this is one of the
so there's a level
right now.
There's even a level above which they call unacceptable risk, which is the equivalent of the social scoring in China. But
yes, that's the prohibition. It's indeed, we have a short list of prohibited AI systems, and then we have high-risk AI systems, and then we have the rest.
What else is in the prohibited?
So we have the social scoring type of AI systems, and the council just expanded it to include this type of social scoring provided also by private companies, because in the original version we only had...
that would be credit scores?
Yes, it could be. It could be.
Wow.
It could be.
Andrew,
depending on how broad the credit score is.
I guess so my first reaction when I read this is it reminded me of this joke in the US tech circles, right? Which is let's have a party. Americans, I'll bring the software. Chinese, I'll bring the hardware. Europeans, I'll bring the regulations. So your advice to me back when we last talked about this was, this is kind of a broad rule set of regulations. So our best advice is take the NIST AI risk management framework and try to operationalize it. But doesn't that contradict what Gabriela just said, which is if I'm in one of these high risk sectors, I'm kind of screwed, right?
Not necessarily. Well, so it depends on what you mean by one of the high-risk sectors. So the EU AI Act basically categorizes AI into 4 different groups. And there's this prohibited group, which is actually really interesting, and I'd love to talk about that.
Credit scoring is prohibited, she said.
I think
a bit broader,
there's a question mark,
yes,
or an
it's
asterisk.
a question mark. It's a bit broader.
That's a big use case, right?
But it's actually, so stepping back, the way that the EU and the US think about privacy and data collection surveillance is very different. And it dates back to World War II and the types of things that, and the Soviet Union, and the types of things that governments there were doing with data. And so even to this day, and I'm not familiar with the details, but the way that modern credit scoring works in the US is not the way that modern credit scoring works in the EU. And so there is a difference. I think the really interesting question is, what is a social credit score? We know what it is in China because there is effectively very little distinction between, private actors and state actors. And so what China is doing with social credit scores, it's pretty easy to say this is just governmental. But when you outlaw that in the EU, what does that actually mean? There's a really interesting question. Is that a credit score? Is that any type of score based on alternative data about, your likelihood to succeed in a particular job in the employment circumstance? Is it about, could it be your likelihood to follow traffic laws? Anyway, you had a real question. And
go back to my question that, I operationalized the NIST framework, but I'm in one of these high risk industries.
It still aligns, not perfectly. There's work to do, but at a high level, if you are in one of these high risk groupings, it basically means they call it conformity assessments under the EU AI Act, but a more kind of an easier way to describe it is just a pretty thorough audit or risk assessment combined with the right types of governance controls. And so the EU AI Act actually specifies what needs to happen for you to have a conformity assessment to certify. I believe organizations can self-certify, but in reality, what it basically just means is what we've been saying for a while with some add-ons, which is you need to have really good documentation. You need to make sure that the model is as transparent as humanly possible. You need to make sure you're doing bias testing. You need to make sure there is independent review, governance processes, all of these things that are already in the map, measure, manage, govern part of NIST. And so these two requirements are not at odds with one another. They're not the same thing, so it does take work to align them. But there is a world, and it's the world we are kind of pushing our clients towards, where if you're smart about this, the EU AI Act doesn't matter that much. What's happening in DC doesn't, we're going to talk about this, but there are all these other efforts. And if you do it right, you can basically have the same foundation for how you're managing the risks of your AI and then you're not going to be, your AI program is not going to be thrown in jeopardy because one jurisdiction creates something that's very intense.
So, Gabriela, we're having this recording in December 2022. The big thing right now in the public mind around AI is ChatGPT. So, is ChatGPT, can you deploy that in Europe post EU AI Act?
Well, funny you should ask that, because actually general AI models were not apparently included in the original AI Act proposal as being covered by its provisions. But in the council version, they are included, which means that they will have to also comply with some of these requirements that Andrew just very nicely laid out. Not all of them, they will not be considered per se high-risk AI systems. They will likely have a special sort of regime, but it will be based on the requirements for high-risk AI systems. So for example, bias testing, right, would be one of the requirements. So to your question, yes, it can be put on the market, and it can be used, but it will need to go through some of the requirements that Andrew just enumerated earlier.
So right now, if you look at the global AI market, the top two players are China and the US. EU has a bunch of challenges, fragmented market, right? So lack of access to data, maybe more regulation. So is this a bit of a self-own in some ways, right? So because it might continue to hold back the EU AI sector, or am I wrong to kind of assume that? I mean, because like Andrew alluded to, there will be rules in the US as well, but it seems like yeah. So Andrew, so what would be the difference between the rules in the US and this EU AI Act and the ability of companies to move more quickly?
So I think, like anything in terms of the US versus the EU, the US is a lot more kind of chaotic and fragmented. On the other hand, in some senses, more practical. In the EU, the approach is, let's get one law. Let's make that law really, really detailed, really, really specific, and then let's put it out there. There's just like a kind of core in the DNA approach to creating and enforcing laws. I think in the US, though, I mean, one of the things that's so interesting is, again, I think for smart organizations, it's not going to matter, because if you step back and you think, as a regulator, what can you really do? What tools at your disposal can you actually do to decrease the risks of AI systems? There's not a whole lot. The field is evolving very quickly. When you talk about generative AI systems, we did a bias audit on a large language model, and it was super interesting. There are some kind of links that we can share about it, but at a high level, no one knows how to do that. There's no like standard way of bias testing some generative AI system. And so when you have requirements to reduce the risk of these systems, there are just a whole lot of unknowns. And so basically at a high level, there's really only one tool that all regulators can clearly do and clearly agree on, which is some type of independent assessment that includes the things that I talked about before: bias testing, transparency, explainability, documentation, governance policies and procedures. That's really the main tool as a regulator that you can say, this is the way to reduce the risk of AI systems. And so it doesn't matter what regulator is looking at these issues. It's all coming out in pretty similar shapes and sizes. And so, more to your question, in the US, it's a lot more sector specific. What we see in New York City, we have a municipal agency that early in 2023 is going to start enforcing very similar requirements on AI being used in the employment context. So the scope is narrowed. And so I'm expecting in the US a patchwork of kind of more narrowly scoped requirements. But again, they all look the same. We can talk about the FDA, actually. The FDA, I think, has been contemplating the most.
So I brought up the NIST AI risk management framework, which I'm assuming, Gabriela, you kind of are aware of, right? So do you think that if you take that and you're in Europe and you operationalize that, that might be enough to start with?
To start with, for sure. And I think Andrew's assessment is spot on how the NIST framework will map with the requirements for high-risk AI systems. But there will need to be fine-tuning. And this is always the case when we have EU regulations like this one, very detailed, very technical. There are some things that you will need to do extra, let's say, but absolutely it's a good start. And the pillars, these are the pillars: transparency, human oversight, documentation, bias testing. Yeah.
With that, so I guess now we can talk about some of these other rules, which Andrew alluded to, the one in New York City and Washington, D.C. Andrew, what is this blueprint for an AI Bill of Rights from the White House? How should I interpret that? Is that just a document that's great to read, or, I mean, what exactly is that document for?
That's a really good question. I have a hard time answering it, frankly. Over the last few years, we have seen an enormous amount of work go into AI policy and responsible AI and ethical AI. And most of it is not able to be clearly operationalized. And a lot of it just kind of floats around. And some of it actually is just direct marketing. And so I think I think it's a good document. I think it makes a lot of sense.
Well, what's the purpose of that document at the end of the day?
So at the end of the day, my instinct is I think it is meant to be kind of a summary of how the Biden administration and their Office of Science and Technology Policy broadly think about and recommend that these issues be addressed. I think your real question is, does this thing have any teeth? Is it going to translate into any actual legislation? And I think the answer is no. I think it might inform some of the different sector-specific regulatory agency approaches. But like when I talk about what the FDA is doing and how they're thinking about regulating AI, and then when you think about the EEOC, you think about all these different sector-specific regulators, I think it's a nice overview, and I think it kind of helps if you want to get a bigger kind of broad brush understanding of what's going on. But if you're worried, if you're a lawyer in the trenches or a data scientist in the trenches, and you want to know, how is this regulation going to change my life that's coming? I don't think that is the document to start with.
So am I wrong to be worried about these rules in the sense that, in the following sense, no one I know in AI or data science or data engineering actually even talks about these upcoming AI rules. So the reason I wanted to have you two on the podcast is, one, I ran into Patrick at that conference and we started talking, and I'm going, my God, this thing is 2023 is just right around the corner. And I know besides you and Andrew, I don't know anyone who actually talks about this to me. So am I wrong to actually just be concerned about the lack of awareness?
I mean, I'll answer that first. No, you're not wrong. Nobody, aside from kind of weirdos like myself and Gabriela and other lawyers, like, no one gets excited about this stuff. And if you're a data scientist, the last thing that you want to do is think about like ambiguous laws that are still forming and that are going to be hard to interpret even once they're passed. If you're a data scientist, you want to be thinking about how to make the most accurate models and how to do that quickly. And so, no, it makes total sense. Before GDPR existed in 2015, data scientists weren't talking about, all
Oh,
these
no,
different
but
privacy.
that's a different situation, because I would say 12 to 18 months before, everyone in the US kind of was preparing their infrastructure for GDPR.
Well, but that's because GDPR was passed in 2016, and then there was a 2-year grace period. So it was passed, and then I would say there was a year where it was actually passed, and then people still didn't want to think about it. And then in 2017, people started to say, "Oh crap!"
But there were the vendors, the Clouderas of the world were already thinking about it. Here, literally, I don't know anyone
Well,
who's
I would say if we're
thinking.
comparing the timeline to GDPR,
Yeah.
so GDPR was passed in 2016. I would say, and then I think all the actual vendor stuff happened in 2017, began to be enforced in 2018. I would say we are in the equivalent of 2014 or 2015. So we are back to, and I remember because I started in my Immunity days.
That's easier to wrap your head around, right? Like you have to make sure that you can get rid of data, and certain steps that you knew you had to do. Here it's a little
I
harder.
mean, there's still parts of GDPR that nobody understands. GDPR has explainability requirements related to AI. They're actually currently the law in the EU is algorithmic systems need to be able to you need to be able to provide meaningful logic about the algorithm algorithm. Gabriela can give the exact phrase, but anyway.
So Gabriela, the best I can do right now when I talk to people about this is the advice that Andrew gave me, which is take the NIST framework and operationalize it. Is that the best advice we can offer right now?
I think so. It's definitely the most practical advice, rather than just observe this complex process overseas and then see where it goes. I think that's absolutely the best advice.
What would you recommend the timing for that work? When should that take place? Early January? Now, early January? As soon as possible?
As soon as possible, I would say, because that's just best practice in any case. We already talked a bit about this earlier, but it's not only the EU that's looking at bringing rules to this. So to give you an example of another big jurisdiction, big market, that's looking to adopt AI law, that's Brazil. They very recently published a new version of the draft AI law that was introduced in Congress last year. And they're pretty serious about bringing some rules around AI. The new version is a bit more aligned with what we see in the EU. And it's also a bit more, let's say, stringent with regard to liability and with regard to some of the rights that people have. Whereas the EU AI Act is very much focused on the obligations of the providers and even the users of AI systems. What I'm seeing in Brazil is a bit of an addition with the rights part as well.
So, Andrew, what's your prediction in terms of, so GDPR, you had a bunch of vendors get ready, but also it led to a new set of consultants and vendors. So what will happen with this wave of AI regulations in terms of the ecosystem? So we have the NIST framework. So can you imagine people taking the NIST framework and saying, hey, we can offer you services to implement the NIST framework?
I mean, so that I have to say, this is a deeply self-interested, conflicting question, because I run a law firm and we help our clients do some of this. So with that flag in mind, I think 100%. I mean, we're already starting to see it. There are going to be law firms that specialize in this, like the one that I run. There are going to be consultants that specialize in it. There are going to be platforms that come and say, here's
can you use AI to make your AI compliant?
Probably not, but you could probably use you could use some type of ensemble model of AI. You can have one focused on transparency and then one focused on bias testing. But I mean, and I'll say this from our perspective, I think automation and software clearly has a role to play. What I think the regulators and legislators in Europe don't fully have a grasp of, and your joke about like China, US, EU, I think is a testament to this, is just how burdensome what they are enacting is going to be. And so I think the only way to do it well, if you are a smart business, is to figure out what can actually be automated and then try to use software to automate it, and then to figure out what can't, and then intelligently use people to do it. Because if we take seriously projections about the adoption of AI, there's just no way to keep up. There's no way to do all of this manually. And so I think it's going to be a mix.
And as you said, there's going to be some kind of grace period where you can say, hey, look, this is what I've done. I've operationalized the AI risk management framework from NIST. So they'll move on to the next company. Unless you're one of big tech, right, Gabriela? Then they won't let go.
I would say so, yes. But I also wanted to add a couple of nuances here. So first of all, I don't think that the EU will have the patience that it had with the GDPR. So I don't think we will see a 2 years grace period. Looking at this legislative package on anything digital from the past year or so, like the Digital Services Act, the Digital Markets Act, which have already been adopted, the implementation period was much shorter than what the GDPR had. So I suspect we'll see something similar with the AI Act as well. So probably not 2 years grace period after we'll see it adopted.
So we've talked about the EU, and then the US might be a patchwork. Maybe best case scenario, there'll be some federal level. But Brazil. So where else? Australia had a GDPR law early on. So where else are we anticipating there will be some action around AI regulation?
I will look very closely at India, and that's not necessarily because of an AI law targeting just AI, but they are currently working on a data protection law, which will have some elements of what Andrew also mentioned for the GDPR in terms of transparency of your automated processes and so forth and so on. And we also know that India is a very, very big market, right? So I will definitely keep an eye on India with priority in this regard. I'm curious, yeah. Andrew, what's on your map?
I would honestly say, and we've had multiple clients ask us for help in tracking, almost every single major market is currently contemplating significant measures related to AI risks. And so Australia, Japan, South Korea, South Africa, Brazil, India, China. If you want to be a global company, like you cannot afford to ignore this trend. Definitely the major players, though, are the ones that we've been talking about.
So so compare it. So GDPR happened, and then you've got a bunch of other rules, CCPA, and so on and so forth. So right now, on the privacy side, companies have the tools and processes so that they can comply globally, right? So anticipation is same thing with AI. They will have the tools and processes so that they don't have to worry wherever they operate, right?
In some weird way, I actually think it'll be easier with AI because I think, again, when we think about the tools that regulators have at their disposal, like what can you actually say about AI in terms of risk reduction that would be meaningful? It's very, very similar. And so Gabriela said, like, yes, you need to fine tune, but the skeleton of what they're saying is going to be the same. I think for privacy, it's a whole lot more complicated. And I think there's a lot more variation about, honestly, what privacy even means. I mean, I know we could debate the same things for AI systems, but in practice, AI is algorithmic decision-making systems. And so anything that makes a decision or supports a decision that will include some traditional software But I think there are a lot of issues that are more difficult and complex in the privacy space. And so this is my biased opinion, but I think for companies that are doing this right, it's actually going to be easier to comply with this next global wave, because I think that it'll be a lot more similar across jurisdictions than GDPR. You have GDPR, you have CCPA, you have all this, what does it mean to be de-identified? There's a whole spectrum on that. What does it mean to have a right to deletion? What does it mean to be able to use data for separate purposes? So I think for organizations that approach this intelligently, I think it should, or at least could be easier than the whole exercise with privacy and GDPR.
So any closing thoughts or advice to data and AI teams? So Gabriela, you go first.
Pay attention to the AI Act, because it will happen. It's not like what we're seeing with US Congress, where we have 40 bills and nothing at the end of the tunnel. This one will definitely happen, and it will have an impact if you want to market in Europe.
Andrew.
Yes. All right. I would give two pieces of advice. One, standardize your documentation. I've said that before. Relatively easy and straightforward to do. You just got to do it. So every model should have standardized documentation. And then two, find your lawyer and start to be friendly with them.
I thought so. You didn't mention NIST.
I did not mention NIST. Well, I can. I'm more than happy to mention NIST. I think NIST would be honestly less advice to the data scientists and more to the lawyers. Okay. And so for lawyers who are looking at this patchwork and saying, what do I do? The answer, I think, is start with NIST, and that's very clear. But for the data scientists, who I think we're talking to right now, it's be ready to standardize your documentation, and then don't be a stranger to the lawyers who are going to come knocking at your door saying, if you want to keep the system deployed or you want to deploy your next system, here are all the hoops you have to jump through. But again, I really can't stress enough how central a role documentation will play in all of this. And so what we find all over the place is documentation is not standardized. It's a little bit on Jira. It's a little bit on GitHub. It's a little bit in Google Docs and Jupyter Notebooks. Putting it all in one place, having a structure, table of contents, will make your life a lot easier when the lawyers come knocking.
Yeah, and with that, thank you both. And of course, the most important advice is what Gabriela mentioned earlier, which is start as soon as possible.